Thank you, everyone. Please be seated. We have one more oral argument this afternoon in the matter of the Medical Assistance Pooled Special Needs Trust of Scott Hewitt versus the Iowa Department of Human Services. Looks like the parties are ready, so Ms. Kron, you may begin. Is it Kron or Kron? 50-50 chance.
Good afternoon. May it please the court, counsel. My name is Laura Kron. I'm an assistant attorney general appearing on behalf of the Iowa Department of Health and Human Services. We are here today in the matter of the Medical Assistance Pooled Special Needs Trust of Scott Hewitt. This is a companion case to the Mueller matter, which was submitted by non-oral submission today. It involves the same parties, the same attorneys, the same operative facts, and the same legal issues. So those two legal issues are broadly related to medical.
Am I correct? Then that will give us permission and all parties are okay with us talking questions if we want to go back and forth between the cases?
I'm anticipating that, Your Honor.
How about you guys? Are you all right with that?
Given that the legal issues are the same, yes.
Okay.
I'm prepared for argument on facts only in the Hewitt matter, but I'll do my best.
Okay, thank you.
So these two cases relate to Medicaid trusts. The first issue are the limitations on the use and disposition of residual funds in a pooled special needs trust. And the second issue is the accounting requirements for such trusts under state law. So in each case, the parties filed cross motions for summary judgment. The Jasper County District Court found in favor of the trustee in the Hewitt case, and the Scott County District Court found in favor of the department in the Mueller case. As it relates specifically to Hewitt, the department believes that the court erred in finding that the trustee could retain the funds and that no further accounting was needed. The letter and spirit of the law make clear that the trustee may retain funds to the exclusion of the department only for authorized purposes, and that the department is entitled to a sufficiently detailed accounting to ensure that any funds retained by the trustee are used accordingly. Such information has not been provided here.
At what point is it determined whether or not they're retained and used for a proper purpose?
This occurs after the beneficiary's death. Typically what happens is the department receives a final accounting detailing how the trust funds are used or dispersed. Sometimes the department receives a check along with that in cases where there is no dispute. And so it's really...
The accounting that said that the funds were all retained. What kind of accounting were you looking for?
A good example is in the appendix on page 20 is in the Schedule B shows what the distributions were during the life of the beneficiary. And so it's line items, and you can see a date.
I wonder about that. Doesn't that give some pause to your client, to DHHS? I mean, this seems like $7,000 for not much in the way of nothing actually being provided to the beneficiary. Am I correct?
That's true. And for Mr. Hewitt, it was a relatively short period of time between when he joined the trust and when he passed away that he didn't really receive any material benefit from that.
Dollars to close, a closing fee, and then $1,900 trustee fee, and I mean, it seems like a lot of overhead and no services being provided. Is that satisfactory to your client?
I think the department would, in this case, I would note that they weren't aware of this before. This wasn't submitted to the department for review as part of the eligibility determination for Mr. Hewitt. And so the department found out about this after death, after these expenses had already happened. But that is one of the key features of why we are concerned about this matter, that the trustee is deducting these fees on an annual basis and has these fees built in, that to the extent they are retaining fees at the end, we want to know what that's for and why that isn't already covered in the fees that they're retaining throughout the life of the trust.
What was the life of this trust?
I think Mr. Hewitt joined the trust in February of 2019, and he died in July of 2019. So, just a couple.
It's a trust, and then there are sub-accounts. With respect to Mr. Hewitt's, would you consider his sub-account kind of its own trust with respect to the Iowa Trust Code and the requirements like for the accounting? And so is there an accounting just for his sub-account and it ends, I mean, his trust is presumably done on the date of his death and then there should be a final accounting?
Expects to see. And so when these pooled special needs trusts cover many, many sub-accounts, and so the department will receive voluminous filings with lots of information typically.
For each one of the sub-accounts. Okay, so then with respect to Mr. Hewitt's trust, and kind of back to my original question, so it ends, the trust then ends at his death, and then the statute allows the trust to retain the balance that's left. What more, at that point, the trust can retain it. Do you agree with that under the statute?
Yes, that there are circumstances where the trust can retain funds, yes.
When you say circumstances, are you talking about then what it's used for? Okay, good. So the statute says retain. It doesn't talk about payment. So is it your position that you're allowed to have an accounting until those funds are all used?
But as part of the department seeing these trust funds closed up, that's what we would expect to see. You're taking these $25,000 in residual funds, and what exactly that's being used for, and is that being used for an authorized purpose?
Retained. I guess that's my point, is the statute says they can retain it. And you keep talking about what it's going to be used for. And I think that the accounting says it's retained by the trust. It's put into this master account to be used for the benefit of other beneficiaries. What more do you want to see than that?
We don't think that the accounting requirement dissolves until the trust is until this last piece where we understand what these residual funds are used for, until that's completed.
Wrote you back and said, we're going to use it to take, to cover these same kinds of fees on behalf of other beneficiaries. I mean, I suspect that's what's going on. Looking at their 990, it seems to be they mostly collect fees and don't provide a lot of service, but suppose it shows that, what is that? What's the significance of that? What are you going to be able to do about that?
That ideally, if there's some sort of more itemized accounting where it's really detailing what these funds are being used for, that the department goes through and says, this is consistent with what we believe the purposes are authorized under the statute and what says in the case law, the benefit of the beneficiary, that it's really a verification, and that as in the Mueller decision, they note that really these trustees hold all the cards as the fiduciary. And so we, as a beneficiary or as a residual beneficiary, have no way of knowing how they're using the funds until we get information from them. And so ensuring that we receive the information to vindicate any rights as a beneficiary under the trust.
Light on for me. What bang does DHS get for their buck? I understand what you're giving up. You're looking the other way at perhaps maybe some assets that could have disqualified somebody from a program or continued program. Why are you guys even in on this game? What bang do you get for this buck?
In terms of recovering funds at the end? Yes. So, since these funds are excluded from eligibility purposes, allowing folks to qualify for Medicaid, sort of the benefit for the bargain is that after death, Medicaid recovers funds from estates or from trusts, funds remaining in these trusts. And so while this particular account isn't a substantial sum of money, there are many pooled trust accounts and special needs trusts that the department monitors, and so ensuring that the funds go back to the department as they are contemplated in the statute.
I mean, you know a lot more about this than I do, but you would have been entitled to those anyway, or because it's reimbursement, right?
The intent is reimbursement for medical expenses.
Anyway, or because of those assets, they would have never qualified and you would have never been obligated to provide coverage. So I'm just trying to figure out, is it a policy decision to do this to help people out? Why is it that the department is involved in this?
It's mandated by federal law that we have these trust recovery programs and estate recovery programs.
Just trying to figure out the political reason for it. I'm trying to figure out how this works.
So the funds that are recovered are used to provide funds for other beneficiaries in the future. So the department is interested in recovering funds from beneficiaries so that they can continue to pay these services forward.
So what you're saying, it's even though you're advancing it in a sense, or looking the other way, your intention is to put it back into the system for someone else.
Was that it's not that, this is mandated by the federal statutes, right? You don't, and the statute, the federal statute is what says that Medicaid gets what's left as long as, from what's not retained by the trust.
That's one subsection of the federal statute.
Section that we're dealing with here. So these are special needs trusts that are put in place that only nonprofits can use, is that right? Or can be the trustee of. And so so Congress has made some policy decisions there related to these particular types of trusts. Do you normally see large sums left in these kinds of special needs trusts?
Typically, no. Generally speaking, these funds are intended to be used by individuals who don't have very many funds, so they're pooled together for management investment to reduce overhead and reduce expenses so that there's more funding available for beneficiaries. And so I think in some of the cases cited in here, there are a few examples where there were large sums, but generally speaking, it isn't a lot of money left over.
Is that kind of based on how the trusts are set up and kind of what their purpose is?
Isn't the state a beneficiary, or isn't DHS a beneficiary under the statute?
Beneficiary, yes.
I guess what is the state, how does the state figure out when another beneficiary is getting too much, as they are here? How do we draw that line?
And so part of that is the function of the accounting, where the DHS receives information and can look at this and determine, based on what the trustee has laid out, whether they should be entitled to keep more of the funds for overhead expenses.
I mean, you're quite apart from what the statute says, just as a matter of trust law, you would have rights as a beneficiary to ask questions of the trustee. Isn't that correct?
And I think that's one of the key pieces that we think that the state trust law is pretty clear in that it entitles DHS to information which it has not been able to obtain in this case.
Is DHS entitled to an accounting of the master account?
I don't know the details on that. Our focus has been on the specific trust account, and I don't know an answer to that.
We're, under the statute, we're retaining the residuary as we're allowed to, and we're putting it into this trust, into the master account, to then use for the benefit of other individuals that are pooled in this trust. But you keep talking about you need to know how it's used, and the statute uses the words retained. So if they put it into that master account, and they're going to use it over a period of time, that's where I'm trying to get at. What accounting are you entitled to with respect to the Hewitt sub-account as opposed to the master account where that money moves to?
If the trustee in this case had provided that accounting of what was happening out of the master trust account and could show funds were moved in on this day and here are expenditures out, I think that DHS probably would have reviewed that and considered whether that met its needs, but that wasn't provided.
And what under the Iowa Trust Code entitles DHS to an accounting of the master account, as if we've kind of established that that's somewhat of a separate trust from the individual Hewitt trust?
I think it is to the extent that that's where the funds go. So as an explanation for really tracking how these funds are moving.
So I guess I don't understand what the remedy is if DHS is dissatisfied with the way the funds are being used. So let's say, in this case, there was, $32,000 put into the trust, roughly, something like that, and $7,000 in fees taken out over several months. And let's say the accounting said this is just going to be used for administrative purposes similar to what we've done in the past. We're just going to draw down the remaining 25. Then what happens?
So generally, these trusts are under the jurisdiction of a probate court, and so if DHS had an objection, they would file that in the case and say, we don't think that this is appropriate use of those funds, and then the court would decide whether DHS's position was correct or not.
In this record on how frequently DHS does that? So would DHS have an objection if the purpose of this was just to pay overhead?
Evidence in the record about how often DHS would object to that.
Can you compare the ruling by the district court in the Mueller case versus the Jasper County case, and why one was right and the other wrong?
So in the Hewitt case, the court essentially concluded that they could move all of these funds to the master trust account, and that essentially alleviated any obligation to provide a further accounting, and that any use by the trustee of any of the funds would be for the benefit of trust beneficiaries because they're running this operation. By contrast, in the Mueller case, which was framed slightly differently, where they focused more, I think, on the accounting piece of it first, that's saying just retaining these funds, and I apologize, may I continue, Chief Justice?
The other side knows, if we talk about both cases, we're going to give you a chance to respond as if you were the appellant, because you were the appellant in Mueller. So go ahead.
That essentially retention in and of itself is not a way to alleviate these obligations and say that this is all wrapped up and done. That because of these state trust law accounting obligations, that the department is entitled to understand what happened to these funds, and that if they are not able to show that the funds were used properly, that they should be returned to the department. And that ultimately was one of the rulings in Mueller, that because the trustee couldn't account for these funds and couldn't show that they were used in accordance with federal law, that they were to be returned to the department. And that specific question wasn't reached in Hewitt. That was just the payback to the department was only in the Mueller case.
Thank you. We'll come back to you in a little bit.
All right, good afternoon. May it please the court, opposing counsel. My name is Elizabeth Meyer, and I represent the Center for Special Needs Trust in this matter. I think the court has recognized that the dispute between these parties is actually very narrow. So I want to start with what we agree on in this case. I think the parties agree that the trust at issue qualifies as a pooled special needs trust under federal and Iowa law. We agree that following the death of the initial beneficiary of the subaccount, the trustee of a pooled special needs trust may retain the funds in that subaccount for the benefit of other disabled individuals. We agree that DHS was a beneficiary of the subtrust account at issue here, and we agree that pursuant to the Iowa Trust Code, qualified beneficiaries of a trust, including of a pooled special needs trust, are entitled to accountings consistent with section 633A.4213 and chapter 633C. I actually want to jump to Iowa trust law because I don't think there is a dispute between the parties about the plain language of the federal statute. It's pretty clear, and I would note that Justice Oxley has noted the word retained, my client believes, is important in this case and really is where this matter turns. So looking at Iowa Code section 633A.4213, that is what governs the duty of a trustee to inform and account under Iowa law. That's an oft-litigated section, not frequently with regard to pooled special needs trust, but with regard to trusts in general. So what that section provides is that the trustee of an irrevocable trust shall keep the qualified beneficiaries of the trust reasonably informed about the administration of the trust and the material facts necessary to protect the beneficiary's interests. We have to break that down a little bit to understand what this means. So first of all, who gets an accounting? Qualified beneficiaries get an accounting. That can be misunderstood. The definition of a qualified beneficiary under Iowa law can be found at 633A.1102 subpart 17, and that is a beneficiary who on the date we are determining their qualification is determined to be A, eligible to receive a distribution of income or principal from the trust, or B, would receive property from the trust upon immediate termination of the trust. Beneficiary doesn't meet that definition. They generally aren't entitled to an accounting. In this instance, DHS is sort of made a beneficiary, or it's clear that they are a beneficiary under Chapter 633C, which expressly provides that they are with regard to medical assistance trusts. There's nothing further provided to anyone in that chapter of the Iowa Code about what accountings should look like for a pooled special needs trust, whether they're different from any other trust. It's not clear. And so really what this boils down to in this case is, when does DHS stop being entitled to receive accountings? This court looks at Chapter 633C, which relates to medical assistance trusts. Everything in that code section contemplates sub-accounts of a pooled special needs trust. So we have an individual beneficiary who's the disabled individual who contributes funds to fund this sub-account. In a pooled special needs trust, I also want to clarify this, really the sub-account, you can think of it as somewhat of an accounting fiction. The trustee is entitled to pool the funds in order to invest them. So it's almost similar to a 401k if you think about it that way. All of the funds are together for purposes of investment administration, but the trustee tracks what belongs to that individual sub-account beneficiary, and that is what gets reported to an Iowa district court. So we don't have an accounting to the probate court about every beneficiary of this national pooled trust. It was Mr. Hewitt, and in the Mueller case, it would be Mr. Mueller. Once that individual beneficiary dies, there would be a final accounting that we're anticipating would show what's happening to this sub-account at the end of the day. That is what was provided here. And what the trustee provided was an accounting that explained.
This is all, good and kind of legalistic, which I guess is appropriate because we're a court. But here's the concern I have. It does seem to me that DHS is entitled to make sure that this Center for Special Needs is fulfilling its fiduciary duties to these two individuals and any other Iowans that happen to be signed up for it. And what concerns me is the publicly available information, such as your client's 990, show a tremendous amount of administrative overhead in there. And, I just, in the last year that I could find, it was $604,000 approximately spent on grants, but $1.5 million on salaries and $2.5 million on other expenses. And aren't they entitled to some of that information so they can see for themselves whether this is actually something that is fulfilling its duties to Iowa beneficiaries?
Question, that information, the administrative fees, that is included in the accounting. So that's not part of Iowa DHS's dispute, is what was charged before Mr. Hewitt's death. That was provided. If DHS had an objection to that information, that could have been a claim that they made in the district court here. If we have an ongoing pooled trust beneficiary in Iowa, for example, that survives for 10 years, there should be 10 years of accountings. I think the record, I'll just note on both cases, there's some confusion if you look at the district court briefing about whether these were filed with the district court. The record will show that they were provided to DHS, so they were on notice. That's consistent with normal trust administration, that it's not filed in court, it's mailed. So in any event, they were on notice. If they had a dispute about the administration of funds for Iowa sub-account beneficiaries, they have that opportunity to make such a claim. So what we're looking at in this case is after that sub-account terminates, are we putting DHS in the position of policing the national pooled trust? And
are. I mean, if the overhead is so high that it's not it doesn't benefit these Iowans with disabilities that are participating in it, shouldn't DHS be able to determine that?
in my position is the federal statute and the Iowa Administrative Code don't currently provide for that.
It bothers me and concerns me. That's another day, another argument. But in the one case, Hewitt, for example, it was only a very short period of time that Mr. Hewitt's money was thrown in there. And to him, I'm sure that was, as one of my kids would say, a lot of money, $26,000. So even though you are justifying that massive overhead, does it really make sense that you just get to swallow that? I guess maybe prorating is kind of what I'm thinking about, is they want an opportunity to maybe kind of think, how much of Mr. Hewitt's lifetime money, the most he's ever gotten, I think it was from maybe a workers' comp case or something like that. But anyway, it seems kind of weird and kind of somewhat unfair to say we get it all. That's kind of why I was talking about the bang for the buck is it seems to me like DHS, yeah, maybe federally mandated, is doing something kind of cool and allowing people to qualify for some programs that if they tried to consider funds, they wouldn't otherwise qualify. So then to snag it all, I'm trying to see the fairness in that. And is that really what's intended in this statute?
I mean, respectfully, it does appear that that's what Congress intended. So the trustee for this particular type of a special needs trust has to be a nonprofit. In this instance, it is a 501c3 nonprofit. It does file 990s. And the funds are retained specifically for the use of other disabled individuals. There's a verified statement in the record from the president of the Center for Special Needs Trusts that verifies that was part of the summary judgment record. That's also set forth in the standing amendment to the National Pooled Trust that was provided to Iowa DHS in response to some correspondence on April 10th of 2013.
To follow up, wouldn't that have been maybe with the understanding they were going to be getting an accounting? Isn't that why we're all here today about the accounting issue too?
I want to distinguish, there have been accounting. So the only accounting that's at issue is accountings that DHS believes it is entitled to after death, after it's been explained the funds are retained for the benefit of other disabled individuals.
Here's the problem. I mean, now I'm going to maybe put it in a legal framework, which is if this is really all one trust, then shouldn't DHS be entitled to information on the trust as a whole instead of you just saying, well, the rest of the sub-account went into this master account of the trust? I mean, under the trust code, they're entitled to information on the trust, not just a sub-account, right?
Is that, no, I don't think that's the current state of Iowa law. I don't think that 633 or 633A contemplate that the state of Iowa is to receive an accounting of the entire national pooled trust. I don't think that regime is in place. Perhaps it could be.
Money. You get all of theirs, but you don't have to show them yours. You show me yours, I'm not going to show you mine kind of a thing.
Respectfully that I follow that. So what the trust had was the contribution of Mr. Hewitt. When he signed that joinder agreement, he knew that the trust could retain his funds to support other disabled individuals following his death. If it didn't retain those, then Iowa DHS does have first priority under the statute for repayment of medical assistance that it paid to him. So hopefully what would happen in the grand scheme of things is that this type of a pooled trust, those funds that are retained from beneficiaries that die will go to support other qualified individuals. And those funds under the federal regime have to be administered in a way that it doesn't disqualify those people from their Medicaid benefits, but it defrays the overall support cost for everyone.
DHS is, part of the sovereign state of Iowa. Can't they, if it's all one trust, why aren't they entitled to audit the whole thing or look at the whole thing? Why do they only get this sub-account information?
Response to that is because that's what the statute currently requires. And that's
Beneficiary for the state of Iowa. Why did our legislature go through this process of putting them in
For the buck question, that's
633C? I mean, what do they get for it? Why name them if they don't really have any rights?
They do have the right to monitor how the funds are being expended, right? So here, because the expenditures of the funds from the Pooled Special Needs Trust have to operate within the overall Medicaid framework, they are put in the position of monitoring what's going on with the trust while that beneficiary is still alive. And as far as bang for the buck for state, Medicaid operatives, that was decided at the federal level. Other states, as DHS has noted in its briefing, have other regimes that require mandatory payback following a beneficiary's death. Iowa has not seen fit to adopt that. They could do that in the future, it appears, based on what's happened in Indiana, based on what's happened in Minnesota. That could be changed in the Iowa Administrative Code. It has not been.
As a beneficiary allowed to follow the money after Mr. Hewitt dies, can they trace or have any right to know what percentage of the $25,000 that went into the master account was used for the benefit of some identified disabled individuals?
Is currently that, no, that's not provided for under the statute, that once it's been retained, that is where the interest of Iowa DHS as a beneficiary of that sub-account is cut off and no further accountings are required.
Right? And tell me if this analogy is wrong. The sub-account is just a way to keep track of the account, the assets of the account for accounting purposes. It's his trust or irrevocable trust. And this wouldn't be different than, for example, a bank that manages 100 trusts for its clients, but the underlying assets might be pooled into some other investment. And then it's accounted for in individual accounts for accounting purposes to provide accounting to the beneficiaries of those trusts. But that doesn't mean because person A is a beneficiary of one trust, they get to peek and see what's in the trust of beneficiary B, even though the underlying assets are pooled and managed by a single entity. I mean, tell me if I'm wrong, but I think that's what you're saying.
Completely with that position, and I would just touch on the fact this was a summary judgment proceeding. Iowa DHS and my client agree that retention and use of funds for the benefit of other disabled individuals is permitted under the federal statute. There was evidence in the summary judgment record establishing that that is what those funds are used for by the center. Really what DHS wants to do, and I'm a native Missourian, they're saying, show me, don't tell me what you're going to do. And we are saying, we only have to tell you what we are going to do under the existing law. We don't have to show you that master pooled trust, what's going on with beneficiaries that could be in other states, for example, to track that through.
Address the Mueller case briefly, since and we'll go beyond time, and that's okay, since we kind of asked a question of her as well, since you are the appellant in that case. Is there anything you want to help? Maybe I'll ask the same question Justice Waterman did. Why did we have a ruling one way in one case and one way in the other? If you want to be heard on that.
And so I believe the underlying legal issues really are nearly identical. You know, the question before the court, the big question that this court has to answer in both cases is when is Iowa DHS's right to an accounting cut off? But I will note on the further error that occurred in the Mueller case. So in that case, the district court made this determination that because the trustee hadn't provided a sufficient accounting, it had breached its fiduciary duty and Iowa DHS was automatically entitled to the funds. That was not an appropriate remedy under the Iowa Trust Code. The remedy for failing to provide a sufficient accounting is clearly set forth in 633A.4213. It is an accounting, and it's potentially fees for pursuing that accounting. You don't get to jump a step and go to a breach of fiduciary duty. There wasn't a claim for breach pending. My client didn't have the opportunity to provide some accounting that said, well, these were Mr. Mueller's funds. We have now spent them on durable medical supplies for Jane Doe, for example. You know, if that is what the court wanted to order, the court could have ordered that. And in fact, if you look at the district court record in both cases, my client reiterated several times, we don't understand exactly what DHS wants. It seemed to be a bit of a moving target. It wasn't clearly articulated what was desired beyond that whatever we were providing wasn't enough. And it's easy to get stuck in a cycle of trust accounting dispute of, you know, you provide some more, they come back and say that's not sufficient. And so that's where I think you could get into an absurd result if we were to order that a pooled special needs trustee has to account for the entire pooled special needs trust following the sub-account death, because money is fungible. So we took this $25,000, trustee, you're saying you spent it over here, but did you really? Where does it end? There has to be some cutoff.
For context, how many individual accounts does your client have under this national trust?
I can't answer that for you off the top of my head. I wish I could.
In Iowa?
In Iowa. I don't think that pooled special needs trusts are terribly common in our state, actually. And my understanding is that my client is perhaps the only national trustee that is willing to operate in this state. But I believe they have, thousands of accounts nationwide that they administer through their nonprofit.
By that. Anybody else? All right, thank you. And if we talk about Mueller again, we'll give you a chance to respond as the appellant. Ms. Kron.
Thank you. So just a few items to respond to Counsel's points. I think, as Counsel acknowledged, DHS has the right and the obligation to monitor these funds while the beneficiary is alive, and our point is that this can't somehow just evaporate the moment that the beneficiary dies, that we...
I'm sorry. When does DHS's interest as a beneficiary end?
I think typically we conceptualize that as once we have the final reporting that everything...
The trust. How's the trust set up so that DHS has an interest? Under the trust language, I understand you might have additional accounting rights, but when does your interest either become a vested interest or the contingency ends?
I think part of that is the determination of what funds are being kept by the trustee, because if they're not kept by the trustee, then they're paid to the department at that point. And so...
So when the trust decides to retain, so the trust can either retain them or pay them to DHS as a beneficiary. And once they've made that decision, then DHS's interest as a beneficiary ends.
Again, once this has been, I guess, resolved and there's a conclusion of whether DHS is going to receive a check in the mail or won't be receiving any more funds.
Is that separate from your account? Okay, so when is that decision made, I guess, when you're going to get a check? I think that, from the accounting, it makes it pretty clear that you're not going to receive a check. So at that point, did DHS's interest end?
I don't think in this case it did, because it wasn't clear. When we're looking at this accounting, we're trying to get an understanding of whether the funds are retained for an authorized purpose, because the way that the federal statute is written and the state obligations, which also instruct that the trustee can't take any interest that is contrary or not in the interest of the beneficiaries, that resolving this retention piece must happen before DHS's interest would be.
Let's say hypothetically you find out that they retain the money and they spend 85% of it on overhead or whatever it seems like they do based on the public information. That's the end of it, isn't it? What else would you do? As long as it's not going out for some private, it may be a bad deal for DHS, but that's something else, that's a different kind of decision. At that point, this is over, right?
That's true. And so part of this is just DHS fulfilling its obligation to make sure that it isn't being used for some improper purpose.
Because I would tend to doubt that that the money is just going out the door to buy something for somebody for some unauthorized private benefit. And so that's really the only purpose of the accounting, is that what we're talking about?
Yes, that really the way that DHS can monitor this and ensure that its rights are protected is to get this information in the form of an accounting, and that the purpose of that in part is to prevent any of the abuses that DHS would be concerned about. And so not that happened here, but the accounting is the way to verify that.
Sorry, go ahead.
Judge Murphy thought it all came down to, well, now that Mr. Hewitt's gone, did the money get paid off to a family member, right? That's the primary question. And if it wasn't, it was retained by the trust, is that kind of the end of the analysis then? Is that the improper purpose that we might be worried about?
In that case, that is what that is what he was looking at, based on the guidance that we have, including in the POMS, and considering this question in the context of the Medicaid framework. I think it's more nuanced than that, and there are other things that we would be worried about them paying for that's beyond just whether the funds are going to a family member.
Respond to the argument that opposing counsel made that if DHS wanted more power, it needed to have those set forth in 633A or 633C as other states do. And that because we don't have any more powers than what are set forth, this information is now beyond DHS's reach.
Justice. I think 2 parts on that. I think the first thing is that what DHS is requesting in this case is fairly within the statute as we currently have. I wouldn't read it as narrowly. I think in some of the other states too, as mentioned by counsel, those cases reflect that the courts thought that those state provisions were consistent with what was required in the federal law. So even though they did have certain state provisions that we don't have here, or there was trust agreement language that isn't what's at issue here, that all of that was reflected in and consistent with the federal law.
Can I ask one final question? With respect to the Mueller Trust and the judge's resolution there, what is your response to opposing counsel's assertion that under the trust code, accounting is really all that you're entitled to?
But it's a separate issue. So there are, in the trust code, the remedies for when you don't receive the accounting. And what the Mueller court was saying was that because you're in violation of the federal statute by not retaining these funds because you move them to this other account, that violation of federal law is what entitles DHS to repayment. That's a totally separate issue from the accounting piece.
Looks like we're done. And I do want to offer one more chance. Do you feel anything needs to be addressed as the appellant? Okay, thank you. Go ahead.
Thank you. I just want to briefly note that last remark. In the Mueller case, this finding by the district court about funds moving, that's been fully briefed. I think it's our position that is a factually erroneous conclusion by the district court that had no basis in the record. This is a pooled special needs trust. I've described that to the court. No money was moved, money was retained. The label of the Mueller subtrust was removed due to Mr. Mueller's death, but that would be a factual error in the court's findings in that case that wasn't supported by the record. Thank you.
Thank you. The case of Hewitt is hereby submitted, and as I stated earlier, the case of Mueller is submitted, and we had, by agreement of the parties, a little bit more discussion on that. Thank you. Court is adjourned for the day.